Hussain-AIBE 17th cohort 2023. Karibu sana, welcome to my online class today, the Indian Penal Code, the first round today, and tomorrow would be the second round. And read what I posted on the screen. Anyone can unmute and read what I posted on the screen.
Welcome to the aspirants of AIBE 17th 2023 virtual classes 10-1-2023. Multiple choice questions on Indian Penal Code. IST 9:10 p.m. to 10 p.m. MSQs on Indian Penal Code. Indian Penal Code, Professor Dr. Mohammed Saheb Hussain, Professor of Law, Saint Monza, Tanzania East.
Yes. Now let us come to our point of the shooting is concerned, and I already posted last time also on the class which I have taken is AIBE. This is the 16th cohort on 18/4/2021. It is available. Okay. Now, first question. The Supreme Court on Wednesday suspended pending criminal trials and court proceedings under within parenthesis sedition of the Indian Penal Code while allowing the Union to reconsider the British era law. And here the options are section 124B, section 124A, C 124B, D 124C. Which is the right option?
Option B is right answer. Section 1 to answer B is right answer. Section 124A.
Section 124 capital A is the right answer for the first question. Okay. First question is a bit easy. Okay, no matter. Let us see. Second question. On October 13th, 2022, the bench delivered a dash decision in the case. Dash upheld the ban, stating that the ban was religiously neutral as it applied equally to all students, and students were hindering their own right to education by violating it. The state itself was not denying access in any manner. Dash, on the other hand, held that the ban should be struck down. Here, there are two dashes are there. The first dash is A, 2 and Justice Sudhanshu Dhulia versus Justice Hemant Gupta. B, split and Justice Hemant Dhulia versus Justice Sudhanshu Gupta. C, 2 and Justice Hemant Gupta versus and Justice Sudhanshu Dhulia. And D, split and Justice Hemant Gupta, later on Justice Shushandu Dhulia. They have given the judgment. Of course, it is related to the education is concerned, and what we discussed is the constitutional law provisions. For that one, I am not asking which case law it is, but I am asking what is the dash, which is the appropriate dashes, A, B, C, D.
Answer B.
D. Sir, option D. Right option D.
Answer B.
D is the right answer.
If you say option B, it is a wrong. If you say option D, it is a right. It is a split decision. It is a split decision. That is answer D, where one justice said, that Justice Hemant Gupta said, ban is must. That is the hijab ban. And Justice Sudhanshu Dhulia said, no, it is not. He is denying that access to any manner dash. On the other hand, held that the ban should be struck down. So the two different opinion is given. Now the supplementary question. In which case law? We discussed this case law. This is nothing but a hijab case law. I gave the different name of the lady. Hijab. Case law. Ashafiya versus State of Karnataka. Please check it. Yesterday we discussed on this case law. Third question. Justice Abdul Nazir unanimously held that public officials can be convicted of bribery or illegal gratification based on circumstantial evidence, the passing away of the primary witness would not affect the case if circumstantial evidence was strongly observed in the case of dash, which is the case law. Here the cases are given: A. T.N. Bharadwaj versus the state of Madhya Pradesh. B. Neeraj Datta versus state of Government of NCT Delhi within parentheses. C. Naresh Kumar versus state of Punjab. The last one, D, is Hazarilal versus state Delhi administration. Taking the bribe. If the direct evidence also not there, if the direct evidence is there but he was died, the primary one evidence, at that instance circumstantial evidence also make the case to be built. It is a bribe. Shoot ABCD.
Sir, option D.
WRONG.
Option C, sir.
WRONG.
Neeraj Datta is right answer, sir. B.
B is the right answer. Neeraj Datta versus state of Government of NCT Delhi. That is the right answer. Is it clear?
Yes, sir.
Yes, sir.
Okay. Next, fourth question. Adultery not a crime anymore. Observed in the case of, I don't show the options. It's the easy case law. Adultery not a crime anymore. Observed in the case of, it's the famous case law. If I show you the option, definitely you can say, I know it.
.497.
Yes?
Section 497.
That is the section that is adultery is not an earlier it is an offense. But what is the case law?
Show the case law, sir. Options.
No, it is an easy case law. If I show the option, definitely you will say. See, if I show the option, I am sure that definitely will say. There is no doubt at all. A. Farhan versus state of another. B. Mr. Mohammed Shamsheer versus state of Karnataka. C. Joseph Shine versus Union of India. D. Anush Sharma, son of Sri D.D. Sharma versus state of Rajasthan.
Joseph Shine versus Union of India.
I told you that if I show you the option, you definitely will say. I want that you should say without showing the option. Okay, the fifth question. This dash of laws and its dash can be seen in the recent landmark judgments that will be given below. The dash of this article is focusing on the recent landmark judgment of the Indian Penal Code 1860. Here, how many dashes are there? 3 dashes are there. And in 3 dashes, A option, evolution, interpretation, gist. B option, interpretation, evolution, crux. C option, evolution, interpretation, core. D option, evolution, interpretation, and crux. Which is the right option among all those things?
D is right answer, sir.
C.
Read.
C.
Evaluation,
interpretation, and core.
The last one that you swallowed. Read once again.
Evaluation,
interpretation, crux.
Evaluation, interpretation, crux is the right in the appropriate answers. So now the next 60th question, sixth question. Homosexuality is not a crime observed or decided in the case of. If I show the option, definitely will say. homosexuality not a crime observed or decided in the case of, it's the famous case law. Without showing the four options, you should say. If I show the option, definitely will show. Yes. Try.
Versus Union of India, sir.
Say loudly. If I show the option, definitely you shoot. There is no doubt at all.
Yes, sir.
What yes, sir, you should say. I told you. See, I know that now you can shoot it. A. Farhan versus State of others. Sorry, here. A. Satyam Sudarshan versus the State of Telangana. B. Siddhartha Babu versus State and others. C. Nawjat Singh Johar versus and others versus India. There is no meaning of giving now. There is no meaning of giving now. I told you already. There is no meaning of. See, without showing, I would like to see whether you can say or not. But you are failed to say. That means still your mind should be very much sharp. And then only you can shoot it. Otherwise you cannot shoot it. These are famous class.
C is right option, sir.
If I shown the everything, suppose I put the hijab total, only eyes should be seen. By seeing the eyes, you should say whether the male, female or transgender. By removing it, you can easily say that male, female or transgender. Am I right?
Transgender.
I am giving the example to you. I am giving the example to you, not transgender. See, if I keep the wheel, wheel means you know wheel, V-E-I-L, not W-H-E-L-L. In Urdu, burkha. If I keep the burkha on the statue, you could say, should say that is a male or female or what. But when I remove the thing, you can easily make it out who is he, or who is she, or who is it. Okay, now let us come to the next point, 8th question. In the case of dash, the topic of acid attack under section 307 of the IPC was brought to light. The case before, the case of Lakshmi, 16 years old girl, was survived after the acid attack. A. Machi Singh versus State of Punjab. B. Neem Khan versus State. C. State of MP versus Man Singh. D. Abdul Saeed versus State of MP. If I say acid attack case law, I am sure that you can say definitely. What is the acid attack case law? Lakshmi versus Union of India. But before that one, there is another case law is there, and which is the exact case law here.
Audio disturbance.
No disturbance, very much clear.
Naeem Khan versus State.
Here the right answer is Machi Singh versus State of Punjab. B. Naeem Khan versus State. C. State of MP versus Man Singh. And D. Abdul Saeed versus State of MP. The right answer is Naeem Khan versus State. Sorry, Naeem Khan versus State. That is the first case law. Later on, the famous case law is acid case law. That is Lakshmi versus Union of India. Okay. Anyone can unmute and read the 9th question. Unmute and read.
Custodial rape.
Custodial rape.
Option A. Machi Singh versus State of Punjab. Option B. Mithilesh Kumar Kushwaha versus State. Option C, Vishal Yadav versus State Government of UP. Option D, P. Mukesh and others versus State for NCT of Delhi and others.
You know what is custodial rape? Police station rape.
Yes, sir. Yes, sir.
It's a famous case law. To my knowledge, it is Machi Singh versus State of Punjab.
Yes, sir.
That is the case law. Okay, 10th class law. SG Vambatkare versus Union of India is upon the dash. Section 124, Section 124A, Section 125, Section 125A.
B is right answer, sir.
Yes?
Section 120 capital A.
Yes, it is the case law which is deals about the
Section
adultery.
Yes? Deals about the
Adultery is not a crime.
Sedition.
అరే నాయన రామాయణం మొత్తం విన్న తర్వాత రావణకి సీత ఏం కావాలన్నట్టు అయింది. Sedition. So many times deals about the
Sedition.
it is a sedition case law. Instead of asking the sedition case law, I twisted it. I put it in this way. AG Vambatkar versus Union of India. 11th question. Prohibiting the two-finger test in rape cases. This is also famous case law. I need not to show the options. Prohibiting the two-finger test in rape cases. It's the famous case law. Option A, State of Karnataka versus Sharif. B, Bhagirath versus State of Haryana. C, State of Jharkhand versus Shailendra Kumar Roy. D, Kushal Rao versus State of Bombay.
C is right answer, sir.
C, State of Jharkhand versus
Jharkhand.
Shailendra Kumar.
Option B.
Shailendra Kumar Rai.
Option C is the right answer. State of Jharkhand versus Shailendra Kumar Roy is a two-finger test in rape cases. 12th question. Granting right to abortion to unmarried women. This is also a famous case law. You are supposed to say. Is also a famous case
C
law.
is right answer, sir.
Yeah. No, you say the name of the case law. Say the name of the case law. If I show the option, definitely you will shoot it. I know it. Granting the right to abortion to unmarried women. A. Suchitra Srivastava versus Chandigarh administration. B. X versus Principal Secretary Health and Family Welfare Government of NCT Delhi. C. S. Khushbu versus Kanyamal. D. Mrs. Indra Uppal versus Union of India and others.
C is right answer, sir. S. Khushbu versus Kanyamal.
WRONG.
Indra
option
Uppal
B.
versus Union of India, sir.
WRONG.
Sir, option B, X versus Principal Secretary Health and Family Welfare, Government of NCT.
RIGHT, right. B
A
is
is
the
right
right
answer.
answer.
Suchitra Srinivastava. Chandigarh
No.
administration.
No, because this is confirmed in the X versus Principal Secretary and Health Family. There, the test is unmarried women. Yes, they said abortion is allowed there. 13th question. Guidelines drafted for the dowry death trials. The court held that section 304 capital B IPC must be interpreted keeping in mind the legislative intent legislative intent to curb the social evil of bride burning and dowry demand. The bench therefore laid down the guidelines for the dowry death trials in lower courts in the case of dash. A. Jyoti Bala and others versus State of Jammu and Kashmir. B. Ajay Singh Chauhan versus State of UP. C. Sadbir Singh versus State of Haryana. D. The State of Madhya Pradesh versus Jogendra.
C. Sadbir
Beautiful.
Singh versus State of Haryana.
If you say State of Haryana, Sadbir Singh versus State of Haryana, answer is WRONG.
Ajay Singh Chauhan versus State of UP. B is right answer.
B is the right answer. That is Ajay Singh Chauhan versus State of UP is the right answer for the 13th question. 14th question. These exceptions are mismatch among the following. I say mismatch. 1. Chapter 4, General Exceptions. 2. Mistake of fact, Section 76 to 79. 3. Judicial Acts, Section 80. 4. Accident, Section 77 to 78. Options A, 1 plus 2. Option B, 2 plus 3. Option C, 1 plus 3. Option D, 3 plus 4. I said mismatch. Which is mismatch among the ABCD?
C, sir.
Say loudly.
C, sir.
Read full.
C is right answer, sir.
1 plus 3.
C is right answer, sir. 1 plus
Read full.
1 plus 3, sir.
Read full means what is after C? You have to read the figure numbers also.
Chapter 4.
Okay. Chapter 4 is general exceptions. 3 is judicial act.
I am not asking in that way. When you say C is the right answer, you are saying C 1 plus 3. You have to read in that way. Or if you say B is the right answer, B 2 plus 3. If you want to say A is the right answer, A 1 plus 2. That is called full reading.
B 2 plus 3.
C is right answer, sir. 1 plus 3.
WRONG. Here a feedback I have
B
given.
2 plus 3.
Feedback I have given. Now tell me which is the mismatch.
A is right answer, sir. A plus 2.
Which is the right answer now?
Option D, sir. 3.
Option D. 3 plus 4 is the mismatch. Is it clear?
Yes, sir.
Yes, sir.
Why you are taking so much time when I have given the option feedback? 15th question. Mismatch the following. Read anyone?
Absence of criminal intention. Section within the parenthesis, section 81, 86, 92, 94. Second, act done by consent, section 95. Trifling Act, section 87, 91. Private defense, section 96, 106. Options 1 plus 2. Option B 2 plus 3. Option C 1 plus 3. Option D 1 plus 4.
Mismatch. Should.
Option D 1 plus 4.
No, option B 2 plus 3.
Option C 1 plus 3.
If you say option C 1 plus 3, WRONG.
Sir, option B 2 plus 3.
Right, it is option B 2 plus 3 is the right answer. See the feedback. Is it clear?
Yes, sir.
Sir.
So now the 16th question. See, it is an easy question, but I have shown it the name also. Who was the first sentenced to death in India? If I give the options, definitely you can make it out. Who was the first sentenced to death in India? Here I did not give the options. Rasha alias Raghuraj Singh, executed on 9th September 1947 at Jabalpur Central Jail, is presumed to be the first person executed in independent India. Now the question, supplementary, even I could not make it out here. In which case law, whether he is sentenced to death? Supplementary question, because they may ask also in this manner. But the supplementary question I already made you, Nirbhaya people is the last execution in 2021 or 2020. Please check it. 17th question.
2021.
Yeah. There are 4 are executed, hanged to death. In which jail? In which jail? Tihar jail. Please check it whether I am right or wrong. 17th question. Under the IPC, dash offences are punishable by death. Option A 7, option B 9, option C 10, option D 11.
Sir, option A 7.
Wrong.
11 is right answer, sir.
11 is the right answer. If I ask you in which section it will deal, supplementary question. 18th question. Capital punishment is laid down as a penalty in several legislative acts, such as number 1, Indian Penal Code 1860, number 2, Army Act 1950, the Air Force Act 1950, the Navy Act 1955, 3, the Commission of Sati Prevention Act 1987, the Scheduled Caste and Scheduled Tribe Prevention and Atrocities Act of 1989. Then the options which are given here is A 1 plus 2, B 1 plus 2 plus 3, C 1 plus 3 plus 4, D 1 plus 2 plus 3 plus 4.
Option B 1 plus 2 plus 3.
Then what is wrong for?
1 plus 2 plus 3.
STSC Act, sir.
Hmm?
In STSC Act, they don't give capital punishment.
No, there is a provision is there. Actually, I want to twist it this one. I don't know whether but anyway, it doesn't matter. I would like to see your caliber, IQ. See, in all the acts, there is a capital punishment. But I thought that I changed it, but I came to know that I did not change it now. You know what I want to change it? But here, what is the right answer here?
1 plus 2 plus 3 plus 4.
B 1 plus 2 plus 3.
Why 4? No, 4 also there.
4 is not related, sir.
No, it is there because I will show you that. I will show you just now.
B is right answer, sir. 1 plus 3 plus 4.
See, actually, I thought of changing it. I don't know why I have not changed it. I made it here open. Yes, it is here. Capital punishment, death penalty. So here I checked it. Compared to human right. Where's your dialogue? I could hear you. What is the example of capital punishment? But I tapped from there only. But what I have not changed it in those acts, which acts also there, death penalty, death sentence in India, IPC, death penalty. Okay. Now I will make it out. See, death sentence and the different statutes. Are you hearing me? Could you see it now?
Yes, sir.
Capital punishment is laid down as a penalty in several legislative acts such as Indian Penal Code 1860, Army Act 1950, Air Force Act 1950, Navy Act 1956, the Commission of the Sati Prevention Act 1987, the Scheduled Caste and Scheduled Tribe Prevention Atrocities Act of 1989, introduced the death penalty for fabricating providing the false evidence that results in the conviction and execution of an innocent member of the Scheduled Caste and Scheduled Tribe. But what I did not change it means, I don't know how I forgotten. I thought of changing this 50 to 50. I thought of changing that 55 to 50. Now I will ask you. But I don't know how I missed it. Because this is also 1950, this is also 1950, and this is 1955. I would like to change to 50. Then I will make it out. 1, 2, 3, 4. And mostly people say this is not there. Means this is not there. Mostly people think, including myself. But then nobody will pay heed. This I changed 1955 to 1950. I thought it changed. But when I read it, I did not change it. So the right answer, suppose if I change it, what is the right answer?
Option C, 1 plus 3 plus
1 plus 3 plus 4 is right answer. I thought I did not change it. I don't know why. Okay, now could you find it from the photo? Who is this lady? I can give the hint also. She is the minister for the Home Department or something. She went to the Goa, and the Goa, they kept the CCTV camera when the dressing room in Febina shop. Now you tell me. There is a case law also, their famous case law on her name. Still you cannot get it.
Give 4 options.
Yes.
Smriti Irani.
Yes. It is Smriti Irani, not Rani. Smriti Irani found a camera installed inside the changing room at Kandol in Febina in Goa. So she registered a case. Of course, she went over there for the holidays. The case is registered under section 354 capital C and section 509 and section 201 of the IPC and IT Act section 66E. So my point is here is I put dash. See here I put the dash. So option A, voyeurism, invasion into privacy, destruction of evidence, capturing the publishing image of private area of any person without his or her consent. B, voyeurism, destruction of evidence, inquiring the publishing the image of the private area any person without his or her consent, intrusion into privacy. C, voyeurism, capturing, publishing image of the private area of any person without his or her consent, intrusion into the privacy, destruction of evidence. D, voyeurism, intrusion into the privacy, destruction of evidence, capturing the publishing image of private area of any person without his her consent. Among the A, B, C, D, which one is the appropriate option among these?
C is right answer.
354 C, 509, 201 and IT Act of 66 capital E. Now you tell me.
Sir, option C.
C is right answer, sir.
WRONG.
Sir, option D.
Option D is the right answer. The reason is 354 capital C is voyeurism. I don't know how many people knows the voyeurism. Looking to the people, those who are changing the dress or doing the activity of the BBC. That is voyeurism. And 509 is intrusion into the privacy. And 201 is the destruction of evidence. And the IT Act 66 capital E is capturing publishing image of a private area of any person without his her consent. I did not ask you the case law name, but it is a famous case law by the name Smriti Irani voyeurism case law, or we can say voyeurism case law. A supplementary question can be asked, what is the name of the case law? Okay? Shall I proceed?
Yes, sir.
Yes, sir.
28th question. Dash, who was a social activist, worker, in one of the Rajasthan's village. She worked under the social development program at a rural level, which was about to stop child marriage in a village, and this social program was administered, initiated with the Rajasthan state government, and sexual harassment at the workplace was discussed in the Vishaka versus state of Rajasthan. And who was the victim in that case law? In Vishaka case law, who was the victim? Here, I am not supposed to show the options, because if you show the options, you can definitely will deal who is the victim and the victim case law. Can anyone tell me who is the victim in this case law of Vishaka? That is harassment at the working place for the women. Yes? If I show you the option, you definitely will shoot. Okay, read the option.
Madhura.
Read the option. Here, cursor is here.
Option B, Palakin Devi. Option C,
Palakin Devi.
Puravan
Please right
Devi.
answer.
Option B, Banwari Devi. Banwari Devi is your right answer.
Option D,
No, sir.
Banwari Devi.
I told you already, if I show the option, you will definitely will shoot it.
Palakan Devi.
Banwari Devi, sir.
I already told you, if I show the option, you definitely shoot it. That means what you said is correct. Did you follow my point?
Yes, sir.
When I show the option, you definitely shoot it. And everybody is saying, Banwari Devi sir, Banwari Devi sir. I gave the answer for you. That is a Banwari Devi is the answer. 21st question. This also I twisted. Dash, a Bangladeshi national who was gang raped by many, including the employees of the railway, in a room at the Yatri Niwas at Howrah station of the Eastern Railway, regarding which GRPS case number 19/98 was registered on 27th February 1998 in the case the Chairman Railway Board and others versus Mrs. Chandrima Bai and others. Who is the victim name? Sir, Chandrima Bai.
No, sir.
And who is this Chandrima Das? Mrs. Chandrima Das, who is she? An advocate, public interest litigation she filed. Then who is the victim? Bangladeshi. If I show you the option, I am sure that you definitely shoot. But anyway, you are not in a position to give the answer. Okay, read. Option A, read.
Option A Srimati Hanifa Khatun. Option B Srimati Hannun Khatun. Option C Srimati Hamza Khatun. Option D Srimati Hanufa Khatun. Answer is option A Hanifa Khatun.
Option A, sir. Hanifa Khatun.
Option D, Hanufa Khatun.
Now you decide which is the correct answer.
A is right answer, sir. Hanifa.
Indian names are Hanifa is correct. Bangladeshi names are Hanufa is correct. So which is the right answer?
A is the right answer, sir.
D.
D.
I gave the tip to you. In India,
Yes, sir.
Hanifa Khatun is the right spelling. But in Bangladeshi, Hunuffa is the right pronunciation. Then which is the right answer?
Option D.
Option D is the right answer. I will tell you the living example to you so that you could understand it. A living example that I will tell you. Can you tell me the Hussain spelling? Anyone?
H-U-S-S-A-I-N.
H? H?
H-U-S-S-A-I-N.
Hussain.
Can you say SS?
S-U-S-S-A-I-N.
This is the Hussain. This is the Asian spelling. Can you tell me what is the African spelling? Anyone?
Hussain.
N, sir.
A-N.
H-U-S-S-E-N.
Hussain.
This is
Ian.
no.
N. Yes.
No.
Everyone commits a mistake. They are writing my name.
A-N.
They write like this. I said
No.
mine is not African spelling. Mine is a Asian spelling. Asian spelling is Hussain. But everybody in Africa, they will write in this manner. My name. Always. I say not Hussain. African spelling that is. Spellings also different from time to time and place to place. Because the situation has come, that's why I am giving. See, I am giving a sound mind is in sound body. This is Asian proverb. Asian proverb. You know what is African proverb? If you don't know, you say pass on.
A sound body
Body,
in a
yes,
sound
sound
mind.
mind.
It is an Asian proverb. What is the African proverb?
A sound body, sound in a sound mind.
No.
Reverse.
A healthy mind is in healthy body, and this is African proverb. Is it clear?
Yes, sir.
So spellings are different in place to place. You know, Maneka Gandhi or Menaka Gandhi.
Menaka Gandhi, sir.
But we know that how to pronounce it. But if you pronounce the letters which are used over there, they will pronounce here Maneka Gandhi. I say there is no Maneka Gandhi. It is a Menaka Gandhi. Okay, now let us come to the next 22nd question. In one of the cases, it was decided, number one, rape is a crime not only against the person of a woman, it is a crime against the entire society. 2, it destroys the entire psychology of a woman and pushes her into a deep emotional crisis. 3, rape is therefore most hated crime. 4, it is a crime against basic human rights and is a violative of the victim's most cherished right, namely right to life, which includes the right to live with human dignity contained in the Article 21. And here I made the options. A, 1 plus 2, B, 1 plus 2 plus 3, C, 1 plus 2 plus 4, D, 1 plus 2 plus 3 plus 4. In this option, which is the appropriate and right and correct answer?
C is the correct answer.
Repeat.
C is the correct answer.
Okay, let me presume it C is the right answer. That is 1 plus 2 plus 4. Then what is wrong?
Rape is therefore the most hated crime.
No, what is wrong I committed?
It is instead of hatred, it is heinous crime.
No, you are very near to it, but they did not use the word in the case law. In the case law, Supreme Court used this wording. Yes, you are very near to it, but you did not take my point. Rape is therefore most not hated crime. It is hated crime. I added R there. It is not hatred crime. It is a hated crime, but I add R. Because that is the wording they used in the Supreme Court. Is it clear? I said it. Okay. So, the right option is, it is a 1 plus 2 plus 4 is the right option. Because it is not the hatred crime, but it is a hated crime. Is it clear?
Yes, sir.
Yes, sir.
Okay, feedback. Buddhistava versus Mr. Siddhartha Chakrabarti. In the case law, they decided rape as an offense which is a violative of the fundamental right of a person guaranteed under Article 21 of the Constitution. The court observed this point only, but it is the case law. Buddhistava versus Subhadra Chakrabarti case law, it is made. So that is, I want to make it clear to you. Is it clear?
Yes, sir.
The above statement is from this case law. I gave in the feedback regarding the rape is concerned. Yes, 23rd question. Can anyone unmute and read? I say read.
Dash an act done pursuant to the judgment or order of a court of justice when the person when the person doing the act in good faith believes that the court has jurisdiction. Bracket close is no offense if it were to be an offense the hangman.
Okay, let me read. If you read in that way, nobody could understand it. Mustafa, you read like a lion. Okay, let me read it. 23rd question. Dash an act done pursuant to the judgment or order of a court of justice within parentheses when the person doing the act in good faith believes that the court has jurisdiction is no offense. If it were to be an offense, the hangman who hangs the prisoner pursuant to the order of the judge would also have to be hanged. Do you know who is hangman? Do you know who is hangman?
Jalad.
Yes. Urdu will say. Then why not the hangman should be hanged? What is the exception? Which
It's for
penal
the
code
order.
gives the exception? Option A, 78. Option B, 78A. Option C, 78B. Option D, 78C. Section.
Section
Option
78
A,
is correct
78.
answer.
Not chorus
Yes, sir.
answer. More
Option
solo answer give
Right
me.
answer, sir.
78B
Run.
section.
78A, sir.
A, section
Right.
78.
C is
Section
right answer.
78C, sir.
78C. 78C is
Option
right
is
answer.
78.
It is merely 78 section is the right. It is merely 78 section is right. No capital A, no capital B, no capital C. Is it clear? Is it clear?
Yes, sir. Yes, sir.
Clear, sir.
Option
I
B,
told
sir.
you, unless I get the answer from your side, I cannot move. Read the 24th question.
In dash, it was held that a man who, in order to save his life from
Starvation.
starvation, kills another for the purpose of feeding on his flesh, is guilty of murder. The doctrine of self-preservation is of no avail in such cases. Option A, Dudley versus Stephens. Option B, Regina versus Dudley and Stephens. Option C, the Queen versus Dudley and Stephens. Option D, Stephens versus Dudley.
To protect oneself, there are 4 men are left when the shipwreck was there. Among the 4, the last one is a minor, not minor, but the young man. But 2 other people, those who are strong enough, because they are feeling starvation, so many days they did not eat it, they killed the younger one and they ate his flesh. And later on, these 2 or 3 men reached to the shore. And they said, we ate his flesh because we are starving and it is a necessity to preserve ourselves. Is it comes under the exception of the penal code? Can you kill another person to feed because you are starving? Whether it is amount to murder or not. And that is what is the name of the case law. It's a very...
Sir, option A, Dudley versus Stephens.
See, I also thought that Dudley versus Stephens, but it is a murder case. No? In murder case, always parties are, one party is an individual, another party is the state.
The Queen versus Dudley and Stephens.
Dudley and Stephens.
The Queen versus Dudley and Stephens. Right answer, sir.
No, sir. One is the relative of the dead person, sir. Dudley versus Stephen is
No.
right.
See, in some places I saw Dudley versus Stephen. But when I saw this Regina versus Dudley versus Stephen, I found a different answer. I will show you, don't worry. First I saw the same answer. In most of the places they wrote the Dudley versus Stephen only. But when I saw R versus Dudley and Stephen, then I found a different story here. See here, they can show here. So Regina versus Dudley and Stephens, a brief fact summary. Dudley and Stephens defendants murdered a fellow young seaman, Parker, in order to save their own lives from starvation. They were found guilty of murder. Synopsis of the rule: killing an innocent life to save one's own does not justify murder if it is under the extreme necessity of hunger. So the facts they have given. Issue is whether the killing of the Parker was a murder considering the circumstances of the case. Held. Yes, it is a murder. Stephen and Dudley to be sentenced to death. The necessity of hunger does not justify the larceny or let alone murder. Stephen and Dudley choose the weakest and youngest to kill, and it was not more necessary to kill him than any of the other grown men. Stephen and Dudley were tempted to kill the Parker, but temptation itself is not an excuse for murdering him. The unfortunate circumstances also don't lend leniency to the legal definition of the murderer. So I saw Regina versus Dudley and Stephens. And some places I saw Dudley versus Stephens. When you see the pictures, in the picture you could see the both are elder, one is younger. Did you see it? R means Regina. So Regina means in Latin terminology queen, and king in Latin terminology you say rex, R-E-X, rex is the king, but Regina is a queen in Latin terminology. So I found it. The right answer is Regina versus Dudley and Stephen, and here R versus Dudley means R means it is a Regina only but not the rex. So that was the thing. Here also I found R versus Dudley and Stephens. In this case also they give the same thing. The facts, the two defendants and the boy between the age of the 17 and 18 were cast away in an open boat in the sea following the storm. The boat drifted in the ocean and was considered to be more than 1,000 miles from the land. After 7 days without food and 5 without water, suggested that the lots should be drawn in the loser being. So they killed both Dudley and Stephen, killed the younger one. So that is the whole story is there. And hence, now you tell me which is the right answer. Yes. Now we can find it which is the right answer. Participants, are you there?
Option B, sir, Regina versus.
Why you are
Dudley
keeping
and
quiet? If you are silent, you are killing me in other way. Okay, 25th question.
B is right answer.
Yeah, B is the right answer. First I thought Dudley versus Stephen. But later on I searched it. No, it is not Dudley versus Stephen. It is the Regina versus Dudley and Stephen. And the Queen, I fabricated it. Suppose if I write R also, you should not say. Suppose if I write R here. Here I wrote R versus Dudley and Stephen. I wrote also Regina versus Dudley and Stephen. You are supposed to tick that option only, which is more appropriate, not R option. Is it clear?
Yes, sir.
Because R stands for Rex, R stands for Regina also. So appropriate answer is Regina. So now 25th question. Sir, why did you keep such a question? Sir, we know it. Read.
The Indian Penal Code is subdivided into dash chapter that comprise sections. Option A 23 and 511, option B 22 and 511, option C 23 and 510, option D 23 and 509. Option A 23 and 511.
The answer is
Option B is right answer.
Option.
which is the right answer? Easy.
Option A.
Option A 23 and 511.
A is right answer, sir.
Option
A
A.
is right answer. 23 and 511.
But somebody is giving the different answer also to me.
No, sir.
Option D, sir.
Sir, 100% correct.
दूध का दूध and पानी का पानी हो जाता अब. How? How? दूध का दूध पानी का पानी. Do you know what is meant by? Read.
The Indian Penal Code is subdivided into 23 chapters that comprise 511 sections.
Now the supplementary question. How many times Indian Penal Code is amended?
105.
89. Sorry.
I asked Indian Penal Code. I did not ask the Constitution of India.
Yes, 89, sir.
And the last amendment is
103rd amendment is last.
Nirbhaya amendment is last. See, what is the latest amendment in the IPC?
Sir, amendment number?
2018. The bill, age of a woman offense, punishment under the IPC 1860, rape, minimum 10 years, maximum life imprisonment, and below the 16 years, the gang rape cases, heinous crime, the age of a person between the 16 to 18 will be considered as an adult for the heinous crimes. So minimum 20 years and a maximum life imprisonment, 16 years and above rape. Yes. If the 16 years above is there, if they did the heinous crime like a rape, but he can be treated as an adult. So minimum 7 years, maximum life imprisonment they can give. So in this way, the Criminal Law Amendment Bill 2018 PRS, it has come into there. Of course, the other things are regarding the CRPC and so thing, and we need not worry about that one. So Nirbhaya case only that age of the boy, I mean, don't say boy, we should not say minor. We can say minor is treated to be an adult if it is between the 16 to 18. Another supplementary question I would like to ask. In the IPC, I am speaking. What is age is exempted that a minor or infant exempted from the committing the crime?
7 years.
9.
7 and 12.
9 years.
If it is below the 7 years, there is no crime at all. If 7 to 12 years is there, the mental maturity will give the sense whether he is capable of knowing what he is doing. And there is one
भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा जय है जय है जय है जय 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 जय
जय हिंद। सारे जहां से अच्छा हिंदुस्तान हमारा।